Thank you very much. Thank you, Kathleen. Thank you, everyone, for the invitation to Elisabeth Lambert, to Nele Schuld, and everyone. I am very happy to be here, and I'm very happy to share this panel and this conference with such esteemed fellow speakers. I've learned a lot already this morning, and I'm looking forward to further discussions this afternoon when it comes to the science. I'm also very happy, and I give a good morning to our former judge Helen Keller, and looking forward to the next intervention by a sitting judge of the court. I think it's very well planned, and it puts me in an easy position, I may say, because as you can imagine, I am a lawyer of the registry, which Helen Keller described as a part of the grey eminence. Is that what you said about us? But as I am working at the court currently, I am under the duty of reserve, so I cannot comment on pending cases. I cannot talk about the deliberations in the past cases as well. So it's very good that our former judge, who has such liberty, could present some details from behind the scenes of the process. And what I have prepared for today is actually a quite technical and detailed, not scientific but legal presentation on where the science actually plays a role in the litigation in environment-related cases before the court. And you will see that essentially they are two overlapping groups. Is on the one hand, the court uses science in its own determination of the admissibility or the merits of a case, and then a second group where the science comes into play in our jurisprudence is also when the court actually adjudicates on how science and how technical evidence was used before the domestic court, and then sanctions it or scrutinizes this domestic decision-making process. So environmental litigation, even though the subject of today's meeting is climate change, this is the focus, I just want to alert you that many of the general principles that may be applicable, or at least that this is our departing ground, they come from all kinds of contexts. So the litigation not only concerning climate change, that it was already said many times, we have cases that are pending before the Grand Chamber, other cases have been adjourned and they will be examined by the court at the later date. But we also have cases related to various components of the environment, various aspects of environmental positive obligations, whether substantive or procedural. But all this case law constitutes less than 1% of our work at the court. So this is a minimal input, if you wish, and workload of the court, but also obviously a lot of principles will come from other cases not related to the environment. I also wanted to say, I have, Kathleen, thank you for your book. I have it actually here with me. We have it in our library. So for any of you who's interested, Science and Judicial Reasoning, not only does she analyze the science and the judicial reasoning of the European Court, but also of other judicial bodies. So this is a very useful read also to me. So I will draw on your work, with your permission, throughout my presentation. So here we come. First of all, procedural aspects. So the principle of assessment of evidence before the court is that of free assessment of evidence. So this is good because anything goes. Anything can theoretically be accepted by the court. We're not a domestic criminal court, so we have a lot of margin, if you wish, and discretion of what to accept and what not to accept as evidence. Even though the court will say that it's cautious in taking the role of tribunal of fact, it may, in certain situations, reassess the evidence on its own, where decisions of the domestic authorities are obviously inconsistent. And you will see it with an example of the most recent case concerning pollution that I will present to you, how this actually works. So normally the court will defer to the findings of domestic courts, but if those are obviously inconsistent or contradictory, then the court will reassess the evidence that is submitted in the case file. And anything really in the case file will potentially be of interest to the court. Obviously, environmental impact assessment report has a very strong evidentiary value, even where the dangerous activity is still in the planning stage. So the court attaches importance to those formal documents that are prepared as a part of decision-making process, and they are issued by domestic authorities. But also the court will occasionally take account of reports drawn up by private experts. So we haven't had a large body of case law. The case I'm citing here from Croatia concerned noise from a bar. So it's not a very scientific or deeply scientific or very complex or controversial issue of how to measure, decibels. But nevertheless, occasionally the court can also have a look at the reports presented by private experts through the parties. Obviously, what is also important, especially in risk assessment, so cases in which applicants complain about future harm, is the record of past accidents. The court obviously relies on international standards in order to establish whether certain thresholds were exceeded or how they would potentially be harmful to health. So the court looks at the body of international law and recommendations. And what is important to understand is that general scientific studies, mainly things downloaded off the internet, and if they are not corroborated by other evidence that is pertaining to a particular applicant or a group of applicants, this will be of little importance to or little use to the court, because we are looking for this impact of a triggering event, so an environmental extreme weather event, for example, on a particular applicant. So we're less interested in the general situation, general impacts that may be, or consequences of a certain phenomenon that may be produced. As Katalin said, I was seconded to the Inter-American Court of Human Rights, so if you allow me, I will have a peek always and compare what's happening there. So what is interesting to me, and perhaps it will be mentioned later today, is that what kind of science are we relying on? And the Inter-American Court of Human Rights, obviously, because they've had a series of cases brought by indigenous peoples, they had a context that was different to official environmental impact reports or expert reports, and they really had a look and could rely to a greater extent than us on traditional knowledge. So the question to all of you scientists is whether, to which extent traditional knowledge is also science. So this is when it comes to assessment of sources of evidence. Now, the standard of proof. So the standard of proof theoretically is that of beyond reasonable doubt. This is a very high threshold for proof, but almost in the same breath, the court always follows in the general principle by saying that such proof may follow from the coexistence of sufficiently strong, clear, and concordant inferences, or of similar and rebutted presumptions of fact. So and actually, on a case-by-case basis, you will see that the assessment, especially those science-intensive cases, are very much dependent on facts. So the court will juggle facts, and you may have cases that are similar on their face, but in fact they will differ as to the detail. So it's important to compare different cases, because this is how the court incrementally develops this case law. And you will see that even though in some cases the wording that is used is that the court requires a direct link or direct causality in a sense, sometimes it engages, it is satisfied with sufficiently close link, and it has made a pronouncement that it could be, even the sufficiently close link could be established on a basis of essentially probabilistic reasoning, which is accumulation of factors such as statistics, reports of general causation. So that was declared for the first time in the Romanian case Tatar. It wasn't really relied on, this principle in that case, but then you can have a look at how the court worked with statistics and the general causation and reports, and how various pieces of evidence were corroborating each other. And I invite you to have a look at the judgment in Cordella and others against Italy. So moving forward to causation, again, what is required under the convention is a proof of a direct impact or risk of such impact on the applicant, not of overall danger of a given activity. So we've had cases which were landmark cases which were declared inadmissible, which didn't get through this, which didn't go over the threshold of admissibility, because it was considered that the dangers that were evoked by the applicants were only general, and they did not translate into a particular impact on an individual applicant or groups of applicants. Then the court says that causal link between the excessive level of pollution and the harmful effects on the applicant's health cannot be automatically presumed in every case. So it is conceivable that despite the excessive pollution and its proven negative effects on the population, and here I cite from a Russian case that I will discuss later in a given city, the applicants did not suffer from any special or extraordinary damage. So the court is cautious when it comes to drawing any automatic conclusions. So you will see the cases in which even though national norms or threshold were exceeded, the court concludes that there was no impact, or vice versa, where even when pollution is within the norms, in theory, the court can come to a conclusion that the impact was so strong that there was an interference with the applicant's private life. It is something that that is all commented on by Katalin as well, the type of causation. So the court relies in general on this but-for causation, or causation in fact, meaning that it does not require that there will be a particular event will be the only cause of a situation of a human rights harm, but it can be one of them. So we are talking, it is important to distinguish when we're talking about causality, is that for those environment-related cases, we're engaging right to life under Article 2, or right to respect for private life and family life and for home, so under Article 8. And what the court looks for is either lethal or life-threatening situation under Article 2, or under Article 8, it looks for the link either with the applicant's physical or mental integrity, in other words, health, in which case, if the applicant alleges that a source of pollution caused a particular health ailment, then obviously the court will want a medical proof, a medical certificate to prove that kind of harm. But this is not, but the argument can also go another way, insofar that Article 8 also covers well-being, or the quality of life. So in this sense, the court here was talking about this sufficiently close link, and even though obviously a direct link is preferred. And when it comes to the health damage, the court has declared its sensitivity to the fact that it is maybe hard to distinguish the effect of environmental hazards from the effects of other relevant factors such as age, profession, or personal lifestyle. So here the court engages in the assessment of all these elements and looks for as much evidence and corroboration as possible. Now, apart from then causation, science is also used and relied on and is a necessary element of a case with those environmental elements when it comes to the assessment of not only the direct but also severe impact, because the court, under its current norms, requires that the impact be severe in order to trigger the protection of Article 8, right to respect for private and family life and for home. So we have developed this notion of minimum severity, which operates in this context, and the court understands this notion as something that is relative, that depends on all the circumstances of the case. So we're using a kind of a shortcut instead of relying really on scientific reports. This is something that Katalin calls epistemic proxies. So intensity, duration, the distance between the applicant's home and the source of pollution, the effects, general context of the environment, so whether the noise or pollution is emitted in the city center in a big agglomeration, or whether it's somewhere where the applicant moved to have a quiet life, this will play a role. So the court has dealt with science and with the assessment of those elements of the case in order to establish whether or not the threshold of minimum severity was met, by not necessarily relying specifically on what the science tells us, but what the common sense actually tells us in combination with those scientific facts. So the court has developed many presumptions, and Helen Keller alluded to that as well. For example, throughout the cases, if you look at this, severe water and soil pollution may negatively affect public health in general. Soot and respirable dust particles can have serious detrimental effect on health, especially in big cities. Severe pollution may negatively affect public health in general and worsen the quality of individuals' life. Even assuming that pollution did not cause any quantifiable harm on the applicant's health, it inevitably made the applicant more vulnerable to various illnesses. You see, so sometimes the court is quite generous in those presumptions. And nevertheless, as observed by commentators, including Katalin, the court is not free from an error, what she calls of epistemic trespassing or arbitrariness, which, in her opinion, may undermine the epistemic legitimacy of the court judgment. And I want to show you an example. This is an infamous case that is commented on often by those who study environmental human rights. This is an older case from 2003, Kirtatos against Greece, in which the applicants were living on land adjacent to wilderness, adjacent to wetlands in Greece. And they were arguing under Article 8. The reason for the use of other provisions is that there is no right to a healthy environment under the convention. So they had to prove impact on themselves by the activity which led to the destruction of those wetlands. So the public authorities authorized the works which led to the physical destruction of this space. And then, even though this permit was then invalidated, there was no follow-up, there was no restoration of the site. So the applicants were complaining that it was basically unlawful, but still they had to prove under Article 8 the connection between the nexus between them and this wilderness. So the court said that the applicants did not show that the alleged damage to the species living in the swamp, they were talking about birds, turtles, other species, that the destruction of those species directly affected the applicant's right to home, even though they lived just next door. And then what is important, and sometimes it's omitted when people comment on this case, is that the court continues by saying it might have been otherwise if the environmental deterioration had consisted in the destruction of a forest in a vicinity. So in other words, without saying anything more than that, the court distinguishes a swamp, basically a wetland, from a forest. And they say, the majority of judges say it might have passed, we might have seen a connection if it had been a forest and not a wetland. And then in his dissenting opinion, one of the judges who was in the minority, he didn't agree with that vote. He said there is no major difference between those two types of ecosystems. So he already spotted inconsistency. So to me, this may be potentially the example of what Katalin calls this epistemic arbitrariness and trespassing, because the court analyzes does not engage with the science of ecology. By the way, the court doesn't engage with it because also the applicants didn't make that argument. I mean, they said there are, there is fish, there are turtles, there are birds in this ecosystem, but they didn't really explain. They didn't certainly use the word of ecosystem services. We know that in other jurisdictions, legal standing of applicants complaining about a violation of the right to a healthy environment can be established on the basis of somebody's ecosystem services that are derived from a particular ecosystem in a vicinity or in an adjacent land. So here, perhaps it's not the court to be blamed really for it, because also the case wasn't argued in these terms, in these scientific terms. But certainly we can comment on it and we can say that yes, perhaps there is some inconsistency also because the judges use common sense rather than a method belonging to this particular science that is at play, science of ecology. Okay, so again, a quick look at the Inter-American Court of Human Rights and also Human Rights Committee, which actually recognizes a connection, a stronger connection or dependence of the applicants on ecosystem services, not only in indigenous cases, but also most recently from the Human Rights Committee in the small farmers cases. So not only indigenous groups, but also people who live off land, who produce, who grow crops on land, who have husbandry activities on land. The Human Rights Committee and also the Inter-American Court recognizes the special attachment to and dependency on the land of certain groups of people. Now, whether it's thanks to science that is brought, that is argued to these cases, or simply that there is a different paradigm that is relied on by these human rights bodies, this is a question I throw to you. I don't think that in these particular cases there was a heavy scientific evidence provided as to how these people really depended on different ecosystem services, but still the approach is quite different to what we have taken so far. Then moving forward, it has already been mentioned, so the science is used for the assessment of the probability and the imminent nature of impact of climate change or of other environmental degradation or pollution, simply because this is again another requirement of the current doctrine. So somebody can claim to be a potential victim of a future occurrence, but this person would have to show substantive grounds for believing that there is a real risk of harm. As you can see from this screen, throughout the cases, whether it's under Article 2, 6, or 8, there is this requirement of real and immediate or real and imminent, clearly identifiable risk. So it cannot be something that is hypothetical or remote. It has to be something that is tangible in a sense that it has a name, you know what it is, and more or less you know that it's coming. Obviously, as you can understand, the definition of imminent will vary from case to case. This is very much dependent on the facts, very much dependent on the science, dependent on how the case is argued, and it's quite a flexible notion in my opinion. So we will see how this notion will be then defined, redefined, or worked with in the pending climate cases. Again, another look at the critics from the academia. Ole Pedersen, you may be familiar with his work. He studied some of our judgments concerning future risks and risk management, and he actually concludes and comments that the court falls a victim of hindsight, bias, and heuristics, in a sense that if the court has a case about the allegation of future risk where this risk has already materialized, the court will more likely find that the risk was, there was a probability of risk at the time when the authorities were supposed to take action. So that's his words, for you to study this kind of case law to see if you agree or if you disagree with that. But then again, a look at Human Rights Committee, the most recent case concerning Torres Strait Islanders, where the Human Rights Committee, even though at the end under right to life there was no violation, the Human Rights Committee works with a slightly different test of reasonably foreseeable threats. So we'll see whether the European Court borrows it or whether it works with the current tests, how science will help the court to define whether the future climate cases are really, we're talking about the imminent nature of impact or not. And then ending this substantive part, when the court is actually itself dealing with science, obviously it will be science will be important for the determination of the last point, so whether or not there was a violation, with a positive obligation on a state, either under Article 2 or under Article 8. So the state has a positive obligation depending on the type of a situation, so whether we're talking about a natural threat, natural disaster, or a man-made hazardous activity, but there is an obligation generally to mitigate dangers, to deter life through threats to life and threats to private and family life. So the state has to regulate dangerous activities, and here actually this obligation, the court has spelled it out, includes carrying out technical and scientific investigations and studies. So the court would require the national authorities to carry out technical scientific studies in order to assess the risks and the hazards of a particular activity that it is looking into authorizing. So this is valid both for industrial activities which are carried out by private or public or private entities, but also to a certain extent to natural disasters, insofar as they were susceptible to mitigation, or insofar as the state had an obligation to reduce the effects of such incidents. And the court says, obviously, that there is a wide margin of appreciation, so you may be familiar with that notion. It operates especially in those difficult technical spheres. So the court has considered environmental pollution, environmental impacts as a difficult technical sphere, and it has left a wide margin of discretion to the state to choose operational measures, to make the choice of them. So, in other words, if the state has undertaken a series of different measures, for example, to combat smog and pollution in the city of Hamburg, even if the applicants claim that the best scientific method, the best available method right now would be to put catalyzers on cars, while the state has undertaken other measures, actually the court back in the day in 2009 was satisfied in this German case that under the wide margin of appreciation, the case was famously myth. This is what Helen Keller introduced to you, so manifestly you found it, because the state actually complied with its positive obligations. So just as an illustration, the most recent pollution case from the court, Pavlov against Russia, Pavlov and others against Russia, which concerned a huge complex metallurgical complex. So you can imagine people living in vicinity, in towns and cities surrounding this post-Soviet industrial area. And the court has, and this is what I want to show you, not necessarily getting into the details, but in this case we can say was easy in a sense that there was a lot of material, scientific material coming from the domestic authorities themselves. So the establishment of facts made by the Russian domestic court was not satisfactory to the court. So at the end of the day, the court reassessed this evidence. This is what I told you at the beginning, that the court occasionally can do it when it considers that the decision-making process in the state was inconsistent. So this is exactly what the court did in this case. But nevertheless, the domestic court has accumulated the evidence. And have a look at these slides. This is the first time that the court in its judgment uses that much information, scientific tables, information about pollution, where this pollution was coming from, which plant exactly, whether it was sulfur, whether it was nitrogen, whether, how many days, and so on and so forth. So you will see that at the end of this judgment, there are many annexes or many tables on which then the court relied, and the judges actually had this information before them, and that helped them to make the decision that in that case there was a violation, because there was an elevated risk both to health and also to the quality of life of the applicants who were living in those areas, which were constantly polluted to the levels that were clearly and many times exceeding the national norms. So this is interesting, and we'll see if the court continues to use science in this way, to engage with it to the point of actually replicating it in the judgment. And now just I want to close with the second aspect of where the court, the European Court, then looks at how the domestic decision-making process engaged with the science, so with the expert reports and with the information that was offered to the applicants. So scientific evidence in national court, it has come under our scrutiny now under Article 6 of the Convention, which offers a right to a fair hearing. So right to a fair hearing also includes equality of arms. And this is very important because the court says that even though it does not lay down any rules on admissibility of evidence, it does not bar national courts from relying on expert evidence. And also it actually considers that an opinion of an expert may be an essential piece of evidence if it falls outside of the judge's expertise and if it has dominant influence on the outcome of a case. So typically environment-related cases are such cases, and the court has said it already in some cases. So it is important that when the parties, when the court appoints an expert, that the parties have access to interview this expert, to read this expert's conclusions and opinions. And so overall, parties have a right to have knowledge and to comment on the expert report that is being used in the domestic proceedings. And these are the general principles. I cannot tell you anything more. I can just alert you and invite you to watch this space, because there are two cases that touch upon this area, one against Turkey, one against Portugal, and they will be coming out from the court in the near future. And then another aspect of the experts, and perhaps many of you, those scientists who are here in the room, are experts themselves, is the neutrality. So the court has recently engaged in another Turkish case with the question of neutrality of experts, and so the national court relied on an expert report or assessment. It was an assessment of an environmental impact assessment, and the experts in the assessment report used language that was offensive to the applicants, and it undermined the applicant's case. So the Turkish, there was a group of residents that opposed to, I think it was cement companies, if I'm not mistaken, that were, that were being authorized. And actually the national court then relied on the environmental impact assessment and on another report. And that report, not only did the experts comment on the science and on the risks involved in the activity under scrutiny, but also they went beyond, and they actually said that the applicants were fear-mongering, that their case was dubious, that really they blew things out of proportion, as there were no risks. So, and also in addition to that, there were some other alleged shortcomings with the use of this report by the domestic court. Here, the European Court finds no violation of Article 6 because and says that experts cannot be held to the same standard as judges. So if you had a judge who would say such a thing at trial, obviously you would have a problem with impartiality of this judge. But experts cannot be held to the same standard as judges when it comes to drafting opinions. But nevertheless, the court does analyze whether or not there were objective and subjective reasons to think that those experts were impartial. And at the end of the day, it was found that there were no hierarchical links between the experts and the judges, and that the language, even though the court says was unfortunate, it did not have an impact on the outcome of the case. So principles of equality of arms and adversarial proceedings are very important when it comes to the work of the experts. And I want to close with the quality of scientific evidence. So this comes from also quite a recent case against France, Burstop 55, and also watch out for a case that is pending against Germany concerning the extension of Berlin Airport. So this know more about this case, but from the French case we have learned that under Article 10, which can conditionally operate and guarantee conditionally, I say, right to access to information in environmental matters, the court has said that when a state is obliged to provide such information by law, such information has to be honest, has to be reliable, has to be sincere, has to be accurate. So overall, it has to be reliable for the applicants to be able to challenge a particular decision-making process. So again, in-depth studies must be corroborated by institutionalized partners, it's useful when the domestic court, when reviewing such information, it actually really engages and gives consideration to possible divergences or uncertainties that are evoked by the scientists. So I'm going to end here actually and invite you to ask questions, and I'm looking forward to engaging with you. Thank you.
Thank you, Natalia, for this wonderfully rich presentation. And I think we will now have roughly 30 minutes for the Q&A. And we agreed with Christian before that I will now pass the microphone back to my co-chair colleague, and then so he will first pick up some cross-cutting issues, and then I will jump in with my own remarks.
Thank you very much, Kathleen. I will be short because I think it's really open to the floor now. Just a couple of things that strike me. What strikes me is, for having worked on health and the courtroom for a long time, is two things. I think that there's a strong history of that, and I think environment should take that into account and look at what has happened during the last 20 or 30 years in health and pharmaceutical industry cases and stuff like that. I mean, there were some points to that in some of the papers, but I think it's general, and not to separate environment and health in that case. And I think health comes back into the judge's office in environmental cases, evidently, because it's always something that seems to be important and make a point for a judge, whereas environment might or might not as strongly in any case. The other thing that I'm concerned about, and that goes into the direction of some of the talks this morning, is I'm a scientist, I'm a historian, and I've been trained in STS departments with a touch of Sheila Jozanov. So I'm always very, very careful of how we portray science, what science does and can do. And I think we've lived through 150 years of science promising progress. And I think it's dangerous for science to promise progress, because that has a lot of fallbacks and drops. I think we need to fairly understand what science can and what it can't. And that's, I think, what the judges' tension, it was called More Than That by Hélène, but I think judges have learned to work with physicians. That's why medical assessments pass easily. There's a joint venture there, and I think that's not maybe true for scientists to the same degree. But I think it's partially as well because science promises sometimes a lot, or has promised a lot for a long time, and it needs to be careful about what it promises and what it can. So that's just to throw it in the floor, and now it's all open for discussion. Unless, Katalin, you want to comment first, and then maybe hand it over to whoever wants it.
Yeah, thank you, Christian. Yeah, I think I would also throw some cross-cutting issues into the table. So first, I think a common theme was the inextricable link between the social and the normative aspects, which also goes back to the truth and justice dichotomy. In particular, I think it was very interesting to see that a lot of you were talking about causation, and we heard a lot about the scientific basis of causation. And then Rupert emphasized that the science may be even clear about the scientific aspects of attribution science and causality. But I also do believe that legal causation is a mixture of fact and policy, a mixture of facts and scientific considerations and normative considerations. And then Natalia alluded to the wide variety of causal tests in law, like requirements as foreseeability, requirements as sufficiently close causal links. So I think it's very interesting to see that maybe even if the science is clear or going to be clear in the courtroom about the scientific basis of causation, establishing causal link legally may still be a challenge for courts, because it's all about the blaming function of causation, whether courts are really ready to blame a certain emitter for the repercussions and the effects of their activity. So and it will bring me to another remark, which is maybe a bit provocative question, but nevertheless, my question is that what if we need more than only translating science? So the ultimate goal of today's event is talk about translating science, but maybe we need more. So first, judges need to understand science in order to translate it, but later on they need to legally interpret these scientific facts. And this again brings me back to the causation issue. So in order to translate scientific causal facts to legal causation, these facts need to be legally interpreted, which may be challenging for courts due to the normative, non-scientific aspects as well. And maybe we also need to transform some entrenched legal doctrines. And now I again talk about causation. So maybe the problem is not about the scientific basis of causal links, but the legal doctrines of causal links, and whether we are ready and can transform them in order to let these climate litigation claims to proceed. And ultimately, maybe we need to so science needs to be trusted by courts, and I'm just curious about your views about the difference between translating science and trusting science. Trust in, and especially distrust in science, came up quite many times. So even Helen was talking about it, but also Professor Trelli and Laura was talking about the distrust in particular scientific evidence. So I'm just wondering, what do you think? How can we boost this trust in science, which seems to be a prerequisite to ineffective translation of scientific evidence? And then maybe just a last question to all of you. At the end of the day, what do you think? Who should do the translation which is a heavy work. So some of you were talking about the role of the parties. Natalia alluded to the fact that the court may not comment on certain scientific aspects because the parties are not framing and not pleading these issues as scientific issues. And then Helen was talking about the costly burden of pleading with science, which may rest on the parties and which may be an obstacle to trust this job with the parties. And then it was also very interesting when Helen Keller told us that the parties have a responsibility in terms of pleading orally these evidence, because this seems to be a crucial point in effective translation. But then, and now I turn to the scientists, to this panel, experts' language may also be a barrier, so maybe experts should also work on this translation. And this is also something that came up in the presentation, and I'm sure that Rupert and Pascal may also have practical experience with the difficulties of speaking in the science language to the courts. So I think these are just my first couple of remarks, and if we have time, I would have many, but I'm sure that there are many questions on the floor as well. So now I just I conclude at this point.
Nela.
Thank you so much to all the speakers. I have a variety of questions, but I will actually turn to the online chat first to give them a chance as well. So we have one question from Hazard Jamali, who says, I wonder whether the ECHR jurisprudence in climate change cases can be influenced by the fear that it may face states' resistance, and should it admit pending climate change cases and hold states accountable for alleged human rights violations? That's a more general question. I'm not sure to the extent that you can answer it, but it's posed. And then Stain Smet from Hasselt University has asked, and I can also introduce him. Hi, Stain. He's an assistant professor of constitutional law at Hasselt University. And he says, it has been argued in the literature that adaptation and mitigation cases should be treated differently. The argument is that climate adaptation comes within the scope of human rights law, but it is easy to resolve for courts, while mitigation cases can or should not be tackled through human rights law. What do the experts in the room and online make of this claim? Should human rights courts indeed focus on adaptation and stay away from mitigation? And lastly, there's a question from Serkan Kiribashi, and I'm sorry for mispronouncing the name if I have done so, professor of constitutional law at Bahçeşehir University. I'm so sorry for these names. My question is to Rupert. Do you think the climate science attribution can be used as an evidence in cases of crime of ecocide in future before the ICJ? And I would also like to add, and perhaps use my power as organizer to say, if we want to extend by 10 minutes and go into the lunch break, then those who are starving can go. But if we want to continue, please, chairs, you can yield your power. Thanks.
Who wants to comment? Rupert, you had a very precise question to end with, so maybe we start with that, and then we come back to the general places, and maybe Helen wants to comment as well. Or
sure. I think with respect to the precise question on ecocide, and I think this also responds to some of the remarks before from yourself and from Kathleen. The way I see the role of climate science in all of this is it's a factual basis on which legal analysis which could be interrogated by legal analysis, rather than in and of itself explicitly providing answers to questions of legal causation that are legal, informed by science, but not answered entirely by science. And I think the same goes for potential future claims about ecocide, whether or not, in whichever venue those sorts of claims are raised, if the question is one of certain certain actions which cause harm to individuals mediated by the climate system and the environment more generally, if there's a question of there being a causal relationship there between those actions and the impacts that result, via the natural world and the atmosphere, then absolutely attribution science could be very informative in those contexts. So I suppose the short and simple answer to that is simply yes.
Okay, so maybe we circulate the word. Natalia, do you want to come back on some? And then we pass it on to Hélène.
Yes, of course. I wanted to add something which we did not discuss so much this morning, but which is, I think, an additional problem. I look at the Swiss case, the Klimaseniorinnen, and we have, I think we have a general agreement that court should take into account scientific evidence. But if I connect that statement with what Natalia has presented concerning Article 6, a question will be, what does the court now in 2023 take into account as, established scientific evidence? Because the Swiss Federal Supreme Court decided on 2020, and according to Swiss rules, the facts are established as they were established by the Swiss Administrative Court. So we have a lack of at least 4 years of development. And the new IPCC report is, much more devastating in the prognosis for Switzerland, the Alps region, than it was 5 years before. So the court has developed some rules how the court could adapt and take new facts, but will this be also in Article 6 cases, in Article 8 cases? I don't know. So this is an additional, rather technical, but very relevant question, at least in the Swiss case. Translation and what comes on. Translation is really important, and I think the parties play a crucial role, and the broader public, NGOs, third-party interveners, they have to challenge the presentation of scientific evidence if they think it is not correct. And then, of course, as Natalia has said it, the court is free in accepting those evidence or not. What follows, I think the court will have to think on positive obligations. All the cases, at least before the Grand Chamber, pending in climate cases, concern mostly positive obligations. And where do the legal obligation starts in an area where we are concerned, everybody in each place of the globe. I think this will be a legal challenge for the court. State resistance, I don't think that this is, a big hurdle for the court. The court faced state resistance in many other areas, and the court had to go forward, and it's good that it went forward. So that's from my side.
I can take the question, mitigation or adaptation. The simple answer is that the court doesn't choose its cases, so it deals with the issues the way they are brought by the applicants. So that's for your community to be strategic about it, I suppose.
Yes, please. Just introduce yourself.
My name is Peggy Ducoulombier. I'm a professor of public law at the University of Strasbourg. I just wanted to say thank you first for all the presentation. That was really interesting, and I was very much impressed by all this knowledge and how it could be used for specific legal cases, although I think that it also puts a burden on parties to use correctly the right kind of science and the right kind of data, depending on what you want to allege in terms of violation, because as you demonstrated, Mrs. Kobylarz, it's not the same thing if you're arguing Article 2 or Article 8, and if you are going past violation or future violation. And you mentioned the Human Rights Committee decision of Billy against Australia about the risk for life, but if I am correct, there was no violation found in this case, and same thing for Sacchi against Argentina. I mean, the case failed as well on exhaustion of domestic remedies, so I can see the interest of systemic interpretation for the European Court of Human Rights, but I was wondering whether, and this is in connection to this adaptation mitigation also debate, whether applicants should try to target their claims towards Article 8 issues as opposed to Article 2 issues in climate cases, since, maybe it could be answered that even if there is a foreseeable threat, it's not immediately foreseeable, or there may be adaptation measure from the state, which might lead a future court to rule on the fact that there is no violation of Article 2, while maybe on Article 8 it would be easier to defend the case, although it might not be what the applicant would like to argue. So that was a general comment. Sorry about that. Thank you.
Do you want to comment the comment?
I'm not sure I know. Yes, you are correct about the Human Rights Committee's findings in Sacchi and in Billy Daniel. This different test was not then implemented in a particular case, but it comes also from the General Comment 36 on the right to life. So it's just to show that it also operates in other contexts. So, I mean, there is a slightly different interpretation of this particular test. And then at the court is something that I forgot to mention. I had it on my slide, but you see, so foreseeability of the risk would be the same requirement, really, whether it's Article 8 or Article 2, because you need to deal with something that is either immediate or imminent. It's just the language is different, really. But also there is this general rule, and it operates for positive obligations both under Article 2 and Article 8, that the state to engage the state's responsibility, the state should have known or ought to have known about a risk. And we either have, and this is a very well-established case law, of a risk to a particular individual, from a specific activity or to a specific individual, and this is something that is well established in domestic violence cases, in any kind of this sort of positive obligation, but also it has been extended through immigration cases to general situation of violence, for example, in a third country, in a country to which a person is going to be deported or expelled. So in the specific context of non-refoulement, the court has relied on the general systemic situation in the receiving country, in a home country, and there is one case which is also very specific, so I'm not sure how much of a general principle we can derive from it, but an Article 8 case concerning a problem of stray dogs in Romania. You have a reference of this case in my presentation. So when the applicant was actually once bitten, and this was in the whole pattern where many people, residents of Bucharest, were under this threat, and there was a record of similar occurrences, then the court accepted this under Article 8. But this is, again, very specific, so I don't know how much of a general conclusion we can derive from this, but it shows that these notions of imminent, immediate are, first of all, fact-based, science-based. They are also flexible. So depending on the circumstances on the case, the court can use already what we have, but also the court can develop, in theory, something new based on having a look at what other bodies are doing.
Thank you very much. Is there any more out in the web, Nelly, that we would want to take into consideration? No, not for the time being. Any further questions in the room? Yes, please.
I had just one more question. So my name is Anne-Sophie Legal, and I'm an environmental lawyer at Strasbourg City and Metropole. And I had a question regarding the type of expertise. We mentioned public expertise of public institutions and also private expertise. And I was wondering, where does NGO expertise stand with this regard, and how do the courts take into account NGO? So NGO expertise mainly for the ECHR, but it can be a more open question for other courts.
Yeah, maybe I can try to answer. So I don't know for before the European Court, but in France, for instance, in climate litigation, the report from NGO, that means the data brought by NGO who made it, was not on the debate. It was not the judge do not have a look of on the NGO productions. It was on institutional, governmental, also public ones, private ones by firm, I mean like report by consulting firm, and also by national and of course the APCC or the UN program of on environment. But it was not the case for the NGO report. Maybe in another country it can be used. I don't know if somebody here has the answer, but in France it was not, because it depends also if the NGO is also the plaintiff. And often in France, NGO who work on climate field are together. So for the judge, it's not. I think if I was lawyer, if I will be a lawyer tomorrow in France, I will not use the evidence from NGO I work with as an evidence. Voilà. If I have answer. Maybe somebody have an answer for the other climate litigation or environmental litigation.
I think that the European Court is in a privileged situation because, as I said, this principle of free assessment of evidence, and really there is no rule on the admissibility of evidence. So what you see very often in the cases in which there are different accounts of facts presented, very often there are cases concerning ill treatment that happens in detention facility. So the applicant would always come up with his or her story, then the officers have another version, then the prosecutor may have another version. So what the court does typically is to present it in the facts. It's something that is different to what the Inter-American Court does, which is already the proven facts. They already sift through them, whereas the European Court presents different versions, and you may see it. The judgments then are very complicated. Those interstate cases now as well, there are hundreds and hundreds of paragraphs, and you have the version of this person, the version of that person, information coming from this report, from that report, and then the court can engage with it freely, really. And I heard also of I don't remember which country, but there was a campaign, Statistical Power to the People, where actually residents of a polluted street were actually distributed measurement kits, and they were installing them on their balconies to produce, to fill the gap that was created by the local authorities, which were not measuring. So I suppose that for the European Court, at least in theory, anything is possible, anything is admissible, and will be informative to the judges.
I also think it's important to recognize some of the sort of nuance in terms of what the reports themselves include. So you could have a report from an NGO which some people might suggest is less credible on certain grounds as a source of evidence, but if that report is largely the NGO were assimilating peer-reviewed evidence from a range of sources, and it's well cited, and really all the findings of this report is just bringing together a set of facts that do have a great deal of credibility. The fact that the report itself comes from an NGO shouldn't necessarily be to its detriment, but the facts themselves underlying it may be very credible. So I think it's just important to reflect also not only who produced the reports, but also what the facts contained within the report say and mean where they're from.
And if I can continue that, maybe it's linked with the question of Katalin, that in this point, how we can use more trustful evidence, scientific evidence, and in this point, if NGO reports have used a procedural approach, I mean, like with peer review and some procedural standards as well, like it's like this kind of report can be more trustful for the judges maybe. So I think it's also a question of procedural questions on this point.
Any further questions? I know Nele has a long list, so go ahead with it.
I do, but I'm also again passing on the mic, this time to Jeff Segers from Ghent University, indeed. He wonders if the complexity of the science can be taken as an argument for judge specialization or the establishment of environmental chambers. This certainly seems to help the Belgian Council of State, which is an administrative court applying inquisitorial proceedings, deal with scientifically, technically complex environmental cases. And perhaps I can add a question on that I have myself, which is to pick up on the points which was mentioned by Helen, that courts rarely invite experts proprio motu. And my question would be, why is that? We have a history of that happening. Is it a mere cost factor? What are the other reasons behind it? And could we potentially resort to this in the future? Again, and it also perhaps links to a more adversarial approach that the court seems to have taken in recent years. So I would be really curious to hear your thoughts on this.
That goes to the lawyers.
I can only tell you that the European Court, the last time it held a fact-finding mission to which it invited experts was in 2004. And nothing ever since, but I will give the floor to Helen Keller, who has more insider's knowledge from the judges and more freedom to speak about it.
Yeah, as I mentioned earlier, fact-finding would be a good thing, but the court has very limited resources. So the court started to go to prisons in Russia, and I mean, the situation is more or less, or was more or less the same. So the court started to believe the applicants, quite on a basic argument that prisons are overcrowded and that the sanitary situation is really bad. The same in Turkey. I mean, it's not possible to go for each and every case somewhere far from Strasbourg only because the state authorities did not their job in collecting evidence. The other thing, why does the court ask rather seldom proprio motu experts? One reason is certainly costs. Another reason is the court does rather engage in a comparative law research. How do the states deal with this kind of issue? Not so much what is the scientific basis for that. And I think that's a very different approach. We don't want to know whether the approach is scientifically justified. We just want to know, is there a European consensus in one or the other direction? That's the court's approach. And probably the public, the parties have to ask more for the integration of scientific evidence, in particular in a field where the scientific evidence is growing so much and is so important for the assessment of legal questions.
Helen, what about the comment about specializing courts on certain subjects? Could you comment on that?
I think it's a good idea. I'm not sure what the sitting judges would think about it, but maybe they can answer themselves. I have the feeling, but this is, you know, from very far away, that the court is rather reluctant to have specialized chamber, because you are supposed to be a human rights lawyer, and this is a broad field, and you have to deal with all the cases, medical cases, whatever, tax law, and you don't want to specialize. That's my feeling. It's also an organizational matter, because you are in a chamber, in a section, and you deal primarily in this section, let's say, with Turkish cases or with Ukrainian cases. And if you come as a German or Belgian lawyer in this section, you have to get familiar with, you know, the big country in this section. And this is already a kind of a specialization, but you don't want to have a further specialization that in this chamber you deal only with environmental cases. But this is only my guess from far away.
I may reiterate that we have less than 1%. The environment-related cases constitute less than 1% of our workload. So I'm not sure if there is a practical need for it. That's number one. In contrast, where there is a practical need in immigration cases, in cases where we receive sometimes hundreds of requests for interim measures from migrants per week, we have judges who on a rotation basis, we would have, and you would know it, we have a judge who is a duty judge, or the judge specialized, assigned to this theme or to this structure. So these cases are processed in a different manner, because first of all, there are so many of them, and also because you have to examine them fast. I think that I remember from history that ICJ made the decision of having a specialized environmental chamber, and it was never used. So the cases, even though there were cases then with environmental elements, they went to where they were assigned in a regular way. And I know that the Court of Justice of the EU actually doesn't have, a formally speaking, a specialized chamber, but it has specialized judges and specialized advocate general. So the cases are informally given to these judges and these advocates to work with, because they have the specialization. But at the court, it doesn't exist.
Thank you very much. Any further questions? If not, maybe Kathleen, I would play this back to you if you want to wrap up. I mean, you've been cited a lot on the book and the rest. So maybe you want to wrap up this first morning session that from my side was really highly performing, very interesting, groundbreaking from the early introduction by Pascal to the legal discussions we are having at the moment. So please, Kathleen, wrap this up, and then we'll hand it back over to Nele and Elizabeth before the lunch break.
Thank you so much, Christian. I will gladly do so, even though I will be very brief, because I know that we are a couple of minutes behind schedule, and I really do not want to threaten the right to food of anyone in the room on the premises. So let me just say that I'm very thrilled that we could hear all of your inputs and contributions. I think all of us learned a lot. It was very intriguing to see this engagement between scientists and lawyers, and that we look at the same coin just from two different sides. And it will be very interesting to see, with all these insights now in mind for all of us after this rich discussion, how the court will build on its former case law in the upcoming climate cases, because I think in a way climate litigation is fortunate to be so young, because it has a rich basis, judicial practice to build on, and it will be intriguing to see to what extent and in what ways the court will learn from previous mistakes, and whether it will, and how it will incorporate good practices from other jurisdictions, or indeed from its own recent practice. I think today's panel was very informative about picking up certain points or aspects of the case law which is really sensitive and difficult for judges, but also we've heard a lot about recent reform efforts or recently developing doctrines or evidentiary practices adopted by the court, but also by which can be adopted by the parties and third-party interveners. So I think all of us as judges, experts, academics, NGOs, or just regular citizens have a lot to do in order to help the courts to be better placed at deciding these admittedly very complex and difficult cases.